May not be nice, but even SNL is not nice. South Park's not nice. These things are social commentaries, jokes, entertainment, and some of them are not nice. But you don't have to like everything. You don't have to like everything said about you, and you don't have the right to tell everybody that everything said about you should be sued for, especially if you're a public official. As such, I ask you to deliver a verdict in Joe's favor on all claims. I ask that because when you look at it, no reasonable person could see it as a fact. No reasonable person could see it as even false light. The community, if they called them, if people called them, that's because the social commentary resonated with someone, resonated with what people experienced in the world. We've lived through a turbulent year, so we've all seen on the news what people are experiencing all over the country. Social commentary resonates because of that. That doesn't make him the proximate cause. That shows a deeper concern in our country that we should be addressing, not sitting here trying to decide if a music video is a fact or not. That's what's at issue here. And I'm confident as you go back in deliberations, you'll come to that conclusion too. And with that, I thank you again for your service, because it is not easy. And what you're about to do is not easy. It takes time and deliberation. It takes hard work. And I appreciate that you guys are willing to do it. And I reiterate again, that's what makes us a great country. Thank you very much.
Go ahead, Mr. President.
Thank you, Your Honor. Nothing Mr. Osborne said about sexually explicit songs out in society refer to specific people in the community, like the songs that are at issue here. It's not the same thing. We all know that. These weren't opinions. Mr. Foreman didn't say, in my opinion, Brian Newland is a pedophile. In my opinion, they're all thieves. In my opinion, I fucked his wife doggy style. He said it like they were facts. And I think Judge Hine is going to instruct you, based on everything that's happened so far, that these were not opinions. They were stated as fact. And your job is to decide whether those facts were true or not. And we know they're not. The case isn't about lemon pound cake. It's about intentional lies designed to hurt people, and they hurt people. If somebody in the jury room says, well, what about his First Amendment rights? You know, and the law tells you, that doesn't allow lies that hurt people. If someone tells you it's just artistic expression, he ought to be free to say what he wants, the answer is he's not allowed to wrap up harmful lies into songs, so-called art, put them out there and get away with it. The packaging of the lie doesn't make it okay. The message was clear. And Mr. Foreman doesn't get to wrap himself in the American flag and say, you can't touch me. I can say what I want, no matter how untrue it is, no matter how much pain it causes people, no matter for how long, because I have freedom of speech. He can't do that. I'm confident you'll tell him he can't do that. Thank you.
Thank you, Mr. President. Let me acknowledge Mr. Osborne.
Your Honor, I didn't mean to interrupt you. My thing is, I was gonna ask before we read the jury instructions, if I could use, if we could have a restroom break for that, because I know it's gonna take some time to read it.
Everybody's gonna stand in their seat and stretch. Nobody's gonna leave the room but you. Because you're pretty prompt with that, so go for it.
Thank you.
I'll just stand up. Blood flowing.
That one's true.
Well, you're on my team. and the court refines the instructions to account for the conduct of the trial. So to the extent that they might have gotten the instructions very quickly this morning, it's not that they didn't know it, it's the refinements, the little tweaks along the way. That's what they're talking about. But I want to thank them because they did good work making it possible for me to get to the point where I can give these instructions to you. The court has the legal duty to prepare the instructions of law. You've heard the attorney's statements, arguments, you've heard the evidence from the witnesses. The court's duty is to instruct you on the law. And then you have a legal obligation to accept the instructions the way they're given to you. It's your sworn duty to do that. You cannot apply what you think the law ought to be. You're obedient, as I am obedient, to the rules of the law. A person who claims that certain facts exist, in this case, the plaintiffs have to prove them, in this case, by what's called the preponderance of the evidence. You've heard me say this before. I'm going to try to go over things you know, but the obligation is called the burden of proof. Plaintiffs have to prove their facts by a preponderance of the evidence. Preponderance is more evidence in favor of their position than opposed to their position, tilting the scales in their favor. There's one element that has a different burden of proof. Clear and convincing evidence, a higher amount, a greater weight of evidence has to be proven with regard to the knowledge or the motive for publishing. But generally think, okay, can the plaintiffs prove their case by slightly more evidence in their favor than evidence opposed to them? There are two claims, what we've called defamation, and secondly, false light, invasion of privacy. In your deliberations, each of those claims is deliberated separately because there's separate rules for each. I'll give you more. But there's separate law for each of those separate claims. There's 7 plaintiffs, each of whom is entitled to their own deliberation. So when I refer to plaintiff or plaintiffs, what I'm saying to you is that side of the room, but you always have to apply these facts individually and separately deliberate each person's claims. If you rule in favor of one plaintiff, it doesn't mean you have to rule for all the rest of them. If you rule against one plaintiff, it doesn't mean you have to rule against all of them. So it's not like an all or nothing verdict. It's 7 deliberations. And I'll use plaintiff and plaintiffs interchangeably, just understand the analysis and what I'm trying to communicate to you. So to go back to burden of proof, preponderance is the greater weight of the evidence that you believe outweighs or is overbalanced by the evidence opposed to it. A preponderance of the evidence is evidence which is more probative, more probable, more persuasive, has greater evidence value to you. Look at the quality of the evidence, not simply the quantity. If it was only about quantity, there would be more plaintiff witnesses than defendant witnesses. So you think, oh, just because of the number of witnesses, someone must prevail, when in fact you look at the quality of the evidence. Don't get hung up on which side called the witnesses. Think about the quality of the testimony, what you took from it, regardless of numbers, regardless of where it came from. If it would turn out in your mind that there's an equal balancing, the evidence opposed to it and in favor are equal, then the plaintiffs have not met their burden of proof because they didn't tip the scale slightly in their favor. If you could decide a fact or an item in 2 different ways, you have to decide it based upon the facts, not guesswork or coin flips or I don't care. So in those areas where it's hard or it's difficult to resolve, you have to resolve it. You can't leave it up to I don't care and I'll just flip a coin or it doesn't matter. Guesswork's not what you're expected to do. The heavy work of sorting out the facts and deciding which side of the scale they go on is the role of the jury. Now, when we talk about preponderance, slightly shifting, we also have to talk about clear and convincing evidence, a different standard for that one element of motive to publish. Clear and convincing evidence is a higher or greater amount of evidence. You have to be more convinced. Clear and convincing means the evidence produces in your mind a firm belief or a firm conviction that that item is true. So preponderance might be, by example, slightly tipping the scales. Firmly convinced is more convinced, greater evidence offered by the plaintiffs with regard to the motive or the knowledge of publication. What's the evidence of trial? Evidence is testimony and exhibits. Evidence is direct and circumstantial. People scratch their heads on this, but it makes sense later. Direct evidence is when a witness has an opportunity to see or hear those things about which they testify. I sat here, I watched the jury take their notebooks and write in their notebooks. Direct evidence, an eyewitness. Circumstantial evidence is different. Circumstantial evidence is when you look at the facts and circumstances surrounding something you saw, and then you make a conclusion that something else actually occurred. I saw the jury box empty. I saw the pencils. I saw the notebooks. I saw the end of the day. The notebooks were all open. There were words written there. So it's circumstantial evidence that the jury took notes. I didn't see you take notes. But from the facts and circumstances that I did see, it's a reasonable conclusion of fact that you did take notes. Why do I tell you that? Most evidence came at you both directly and circumstantially. Things that I personally saw, and then things that happened as a result of what I saw. Circumstantial evidence is fair game as much as direct evidence. Direct evidence isn't better. You might think it's better when in fact it's not always better, because the witness didn't tell you that they were blind when you thought they saw something, or it was foggy, or the lights were bad. So when you think about the evidence and how to weigh the quality of it, what a person saw, what they heard, what they personally experienced is good evidence, direct evidence. But so is the circumstances around that testimony. They're both fair game. Often people infer that something exists based upon the circumstances and inferences. I inferred the reasonable circumstantial evidence that you wrote in your notebooks. That's fair. But I'm not allowed to infer because you took notes, therefore you also did something else. You can't stack an inference that something else occurred on top of something else you thought occurred, on top of something else that could have occurred. The idea here is what we call remoteness. It gets more and more unreliable the more remote you get from the first circumstantial evidence. If you want to say the circumstantial evidence is reliable, great. If you want to infer that that's reasonable, great. But don't stack another, well, now I suppose something else happened. And if that happened, then something else should have happened. It's stacking, it's called remoteness. Then it gets unreliable. With regard to the exhibits, you saw exhibits, there was testimony related to them. Consider whether the exhibits are in fact what they're portrayed to be. You decide what weight, if any, the exhibits have to have when thinking about the testimony involving them. Exhibits in video can speak themselves, but sometimes paper and other exhibits don't. So you have to consider what the witness said in light of how the exhibit was portrayed. Don't make inferences or conclusions based upon the number of exhibits. Remember, I want you to look at the quality, not just simply the number. Like theoretically, the plaintiffs had more number of exhibits than the defendant. Don't care, don't count numbers. Look at the quality, make the content important. You'll have like physical, tangible paper exhibits back there. When you get to the video or the data-driven exhibits, you'll have a computer back there so you can use that to look at the exhibits. So if it never works that way, so I always offer the bailiff services that he can come back and, as you saw, make the technology work. So if you struggle back there with plugging in a thumb drive and finding the drive and then turning it on, we would expect that. I'll tell you how to communicate with us, but just ask for help. We'll send back a very capable bailiff and he'll save the day. Evidence is not what the lawyers say. You heard opening statements, closing arguments. That's not evidence. It's helpful, it's necessary, it's built into the system, but it's not evidence. If a statement was asked and the question was not answered, there's no evidence from the question. I did that once or twice to show you how it works. Just, you might have thought the answer was going to be yes because the witness was shaking their head yes. The witness is, yeah, I understand the question, and the answer is no. So you can't use body language to get an answer that wasn't spoken from the record. I don't think that happened too often. But remember where the evidence is. It's the exhibits and the witness statement, not the lawyering side of the case. There was times where I sustained objections and handled the lawyers the way I thought was necessary. I always ask people to apologize or accept my apology if you thought how I handled the lawyers is any kind of a comment upon the quality of the case. Like, I try not to do that. But you might misunderstand that in scolding a witness or handling a lawyer, I was expressing an opinion. I love it when you guys show up because I don't have to decide. It's like I always try to make sure I'm neutral in my facial expressions and my voice tone, but sometimes I just don't get that done. An important role for the jurors is to weigh credibility. Credibility is assigning believability, assigning weight to the evidence, assigning weight to the witness testimony, assigning weight to the exhibits. When you weigh evidence, you're basically deciding truthfulness. And as odd as it sounds, it's what we do all the time. We weigh credibility continuously each day. In weighing credibility, you should consider the appearance of the witness on the stand. Consider the manner in which they testify. Did it seem straightforward? Did it seem honest? Did it seem evasive? What did it seem to you? So you're using your eyes and you're using ears to weigh credibility. Think about how reasonable their testimony was in light of the subject matter of the trial. Consider education, interest, bias. Consider if they were frank with you or not. We use these tests every day to decide whether we want to rely upon or find a person believable or not. As I told you before, every witness took an oath to be honest in their testimony. The oath does not bind you that just because they're talking, I have to believe it. In fact, you have to parse it out because people could very honestly get up and say, I believe this to be true, when in fact they're misunderstood and wrong, not lying. So recognize you can parse the evidence. You can believe everything a witness said. You can believe nothing a witness said. You can pull out the pieces you think are credible and ignore those that you think are not credible. And then you shuffle that entire deck with every witness along the way. As a rule, we want people only to testify, general rule, about things they heard and experienced and saw, firsthand testimony. So that's the general rule. But then we violate that general rule because we let people express their opinions about what the facts or circumstances mean that they experienced. So in deciding what their opinion means and how you weigh their opinion, you do the same thing. You're allowed to hear their opinion. It's evidence. But you have to, again, parse it out in terms of the credibility test. A person can give you an opinion, and you might go, I don't believe that because that's not in their subject matter, or they don't have enough knowledge, or their emotions got the better of them, or they have an interest or a bias or whatever. And you might go, no, it's a completely valid opinion because of whatever credibility factors you have. So we give you direct testimony, we give you circumstantial, we give you opinions, and then tell you to weigh out those things that you find believable, credible, and otherwise. In this process, the jury sits around as a committee. And it might be that you find a person credible, the other person finds somewhat credible, and the other person finds not credible. Expect that to happen. And then resolve those differences back there. There's more about that later, but in this whole deliberation process, that's normal. Somebody said while they were here, yeah, I'd served on jury. No, it wasn't easy. It's not meant to be easy. It's important. I just have to explain the rules enough and then tell you don't get your feelings hurt when you get back there and begin the discussion. The instructions I gave you so far would be relatively common in most trials, because those are general rules for how to do the job as a juror. The next set of instructions in the middle, I call substantive instructions. These are the law that applies, the rules that apply to this set of facts, these claims. You'll have sets of these instructions to go back over. So I have to read them to you in the party's presence, but you're not expected to remember all this. You'll have your opportunities to go back over it and get schooled later. So these are the substantive instructions. Again, two claims. One's called defamation. The other's called invasion of privacy based upon this false light publicity. They have separate instructions. I put them right next to each other, but the rules for the one claim are not the same as the other. There's overlap, but they are a separate set of rules. So don't apply the rules for defamation to the false light publicity claim, because you went across the line of their two separate causes of action. With regard to defamation, each plaintiff claims the defendant defamed him or her that then caused them damages. To establish defamation, each plaintiff must show that a statement, that could be oral, written, video, was portrayed a fact that was published. So the statement was made, or statement of fact was portrayed and published. Second, that the statement was untrue. Third, that the defendant acted with malice, actual malice, or reckless regard for knowledge of the truthfulness, and that they suffered injury. I'm going to break those four apart. Okay, so again, the statement was portrayed as a fact. It has to be published, so that's all rolls together. That the statement was untrue. The defendant acted with either actual malice or reckless regard about the truthfulness of it, and then that caused injury. Plaintiffs are considered public officials. You heard a lot of that. So that's where the clear and convincing evidence standard applies. So what you're doing is taking on the element of the defendant acted with malice or reckless disregard about the truthfulness of it. That's the higher clear and convincing proof. So on that element, it's not just a preponderance. On that third element, it's thoroughly convinced about his motive for publication. Clear and convincing evidence means you're thoroughly convinced about the truthfulness of motive for making or publishing the statement. What's actual malice? This knowledge in the publication. Actual malice occurs when the defendant makes a false statement with knowledge it's false. The second part of that test, it's either published with actual malice or published with a reckless disregard about the truthfulness or not. So reckless disregard means that a defendant acted while aware that the statement was probably false, or that the defendant entertained serious doubts about the truthfulness and didn't inquire. The defendant's failure to investigate may be considered evidence of reckless disregard or evidence of falsity when the defendant had serious doubt about whether it was truthful or not. So actual knowledge of falseness or reckless disregard about something that's probably false. Those elements have to be proven by the higher amount of evidence. A statement is false when it's not substantially true. It's substantially true when the essence of the statement is true when you think about the statement as a whole. The defendant's statements or portrayals must be given their ordinary meaning in that context, in that circumstance. So you can't just pull a line out. You have to look at the whole portrayal of the statement. In deciding whether the statement is false, you're not to consider the defendant's subjective belief. You consider whether it's true or false from an objectively reasonable perspective. So it's your perspective about truthfulness, not what the defendant thought at the time, because we can all think of things that are unreasonably thought. So we apply an outside standard, an objective standard, not the defendant's subjective belief. Now, this idea about the concept of truthfulness is where we find the fact that truth is a defense. So if the statement is true, then there could be no defamation. Plaintiffs also have to prove that the statements were published, portrayed, made. Published means that the statement was read or heard by another person other than the plaintiffs. From the testimony, as a matter of law, the courts has determined that publishing or portrayal is not an issue. Nobody pushed back. It's not anything you have to decide. I'm telling you as a matter of law, that element is uncontroverted, that the defendant published, the defendant portrayed the statement. So of those four, one's been resolved by the court because there's no contrary evidence. Now you're down to analyzing those three statements, elements, if you will. You need to know how to differentiate between facts and opinion. In a defamation claim, this is important. This is over on this side of the first claim, fact versus opinion. The distinction between portraying a statement of fact and portraying a statement as opinion is crucial. It's an important distinction. Portraying a fact or portraying an opinion. Only statements of fact can be the basis for a defamation claim. Statements of fact could be untrue, which is the nature of a defamation claim. If I'm expressing an opinion, there's no way to decide whether it's true or untrue, so you can't defame someone in expressing an opinion because there's nothing verifiable about it. It's an opinion. So a defamation claim has to involve an untrue fact. To determine whether a statement is fact or opinion, you apply these four factors in their whole context. You look at the specific statement, the language in the statement. Consider, importantly, whether that statement is verifiable or not. Then apply the general context of the statement, and then think about not only the context of the statement, but then the broader, how the statement could be received or heard. Start with the statement, is it verifiable? Consider the circumstances of the statement in its context, and then go farther out to the statement's circumstances in general. Look at the precise wording. Determine whether a reasonable hearer or listener would view the words as portraying fact or portraying opinion. If a statement is made and it's considered an opinion because it's not verifiable, there could be no defamation. If a statement is made and it contains verifiable information, then it can be the subject of a defamation claim if the verifiable statement is untrue. If you find that the statement was portrayed to the public as a fact, that the portrayal was false, it's a fact that it's false, plaintiffs have proven their case. If you find that it's not a fact, or that the fact was true, then the defendant prevails. This is why I give it to you in writing.
Okay, I forgot about that.
General instructions for defamation are done. Those rules apply to that claim. These rules apply to the invasion of privacy false light claim. There's only one place where I'm going to tell you to overlap the instructions. So don't overlap all the first instructions in the second bucket, separate set of rules. The person who invades the right of privacy of another person can be subject to liability and the harm that comes from invading that other person's right of privacy. The right of privacy is the right of a person to be left alone. It's the right to be free from the unwarranted appropriation or the exploitation of a person's personality or their private affairs in such a manner as to outrage or cause mental suffering, some sort of shame or humiliation to the person. Each plaintiff claims the defendant violated his or her right to privacy by publicizing false information that places them in a false light in the public. Each plaintiff must prove that the false light in which they were placed would be highly offensive. It's a highly offensive place to a reasonable person, not their subjective, but would a reasonable person find that they were put in a highly offensive place. And the defendant had knowledge of or acted with reckless disregard to the falsity of the publicized matter. Reckless disregard, falsity, and actual knowledge are the same definitions from the first section. So that part of the first instructions you can carry over. Actual knowledge, reckless disregard, and falsity, I'm not going to redefine. That part you would read over. But it's a different test. Was the particular plaintiff put in a false light by the false information? False light means the defendants know that the plaintiff, as a reasonable person, would be justified in feeling seriously offended and aggrieved by the publicity, seriously offended and aggrieved by the publicity. The plaintiff's privacy is not invaded when it's an unimportant statement that's made. It's only when there's such a major misrepresentation of the plaintiff's character, history, activity, some fact, that it might be reasonably expected that a reasonable person would be highly offended. Determine whether the statements made by the defendant would place a reasonable person in a position of false light, not merely whether the plaintiff believed they were in a false light. So this is the objective perspective that we use for juries. You're the outside public looking in. Do you consider it reasonable or not that they would be highly offended? It's not their subjective belief, it's the public's perception. To be highly offensive, the plaintiff must be justified in the eyes of the community as feeling seriously offended and aggrieved by the publicity. The statement must be such a major misrepresentation of their character, of their history, of their activities, of their beliefs or facts about them, that they would be seriously offended in the eyes of a reasonable person of the public. False has the same definitions I gave you, not substantially untrue. The fact versus opinion distinction doesn't apply from that, so you don't have to do the fact versus opinion analysis. If you find that any one or more of the plaintiffs proved all the elements of false light, invasion of privacy, then you would enter a verdict in their favor. If you find that any one or more of the plaintiffs did not prove all the elements of false light, invasion of privacy, then you would rule in the defendant's favor. I'll say it again, there's 7 determinations on false light, there's 7 determinations on defamation, and you make them separately. If you find for a plaintiff on either one or both of their claims, then you go to the question of whether the defamation or the invasion of privacy caused damages. There always has to be a connection between the false statement and the damage, or the false light offensive position they were put into, and the damages. A person who seeks to recover damages must prove not only that the other party caused the harm, but also that the conduct proximately caused them injury. Proximate cause is an act that in its natural and logical sequence caused the injury. There was an example of the defendant could have caused, but was something else actually the cause. You have to sort out whether the person's injury came from the defendant's conduct or came from somewhere else. With regard to damages, the purposes of damages are to compensate a plaintiff for injury, to their reputation for any kind of monetary loss, for emotional distress, so it's compensation, to vindicate the plaintiff, which helps restore their reputation, and to dissuade others from publishing defamation statements or false light statements. If you find that any one or more of the plaintiffs' claims should be ruled in their favor, then you have to have the greater weight of the evidence, a preponderance of the evidence about the amount, not clear and convincing proof about damages, but in your deliberations, slightly more evidence in favor of the amount to award is the test, the burden of proof. Take into consideration all the facts and circumstances and evidence, decide what amount of compensation should be awarded to each particular defendant or plaintiff. These are the kind of types or examples for which you can award money. Harm to their reputation, including exposure to public hatred, public contempt, ridicule, or public scorn, and or loss of professional income and or out-of-pocket expenses, and or physical, mental anguish, pain, and suffering, loss of society, companionship, and friendship. Those are all eligible factors or categories by which to compare or measure damages. It could be that the award of damages is not easily determinable and you can't put an amount on it. You can still order what's called nominal, or I'm going to use the word token damages. So if you find in favor of the plaintiff, then you have essentially the opportunity to go from 1 to wherever. Nominal or token would be the 1 or 10 or some low amount as a statement that they prevailed and entitled damages, but you're not bound by anything more than 1 in your deliberations. But if you find for a plaintiff, then there has to be an award for damages, assuming there's a causal link between the defamation or the false light and injury or harm to reputation, emotions, etc. As a matter of law, the court determined previously that the claimed damage to the defendant's home was permitted under the circumstances of serving the search warrant. Therefore, you do not make a reduction for any damage that the defendant said happened to his home during the search warrant. The court previously found, as a matter of law, that that's expected or permitted as a result of serving the search warrant. So you don't subtract based upon whatever you think happened to his home. In your deliberations, a plaintiff cannot have double recovery. If you find defamation and invasion of false light privacy, you don't issue an award under each category. You can't award pain and suffering, say this, emotional distress once and then emotional distress twice. You would issue one order as long as there's either a claim for defamation or a claim for false light, invasion of privacy. Don't double up if a plaintiff prevail on both claims. Your verdict form doesn't really make that possible. You'll get there, we're getting close. Another concept that came up earlier was something called punitive damages. You are advised that punitive damages are not a part of the deliberations given to you right now. I haven't talked about punitive damages. Punitive damages are meant to be punishment damages for conduct. That's not a part of your deliberations. You're deliberating what we call compensatory injury-related damages. An award of punitive damages can only be given if there is a compensatory damage award. If a compensatory damage award is given, then you come back with a different set of instructions and you have arguably a second deliberation about punitive damage. You don't have to award it, but they aren't all lumped in. So don't think in this first phase, oh, the punishers are really mad. That's not where we are. If you find any plaintiff prevails on either claim and it caused injury, compensatory, actual repair damages, if you will, are what we're here for, not punishment. That's a second deliberation. The verdict forms aren't that hard to understand once you know what you're doing. Each plaintiff has 3 pages. Page 1 is the claim for defamation. We, the jury, being duly impaneled, find in favor of, and then it says Sean Cooley or defendant, circle 1. So you have to circle whether the defendant prevailed on Sean Cooley's claim for defamation. Then there's signature lines. Regardless of that verdict, you go to the second claim. So the next form is we, the jury, find in favor of Sean Cooley or defendant for the false light claim. The instructions at the bottom of each page say, now go to the next page. If you find for that plaintiff on either of the first 2 forms, then you go to form number 3, which is damages. Damages is 1 line where you put a number in. You can take notes and you can split it out. You can do calculations. You can decide how you get to it. But there's 1 line. So that would be for Sean Cooley. And it says Sean Cooley on the first 3 pages. Then the next 3 pages say Justin Cooley. Same 3 pages. So the first 2 pages find in favor of that plaintiff or the defendant, circle 1. Next one in favor of that plaintiff or defendant on the second claim, circle 1 of those options. And then you go to the damages form only if the plaintiff prevailed on one of the first 2. They're all numbered, they all have names on it. They should be easy to follow. You can tell me later. What do you do when you go back there? The first thing you need to do is pick a foreperson. Now the foreperson is not the shop foreman, they're not the boss. They don't tell you what to do. The foreperson job is to organize the discussion, engage people, keep track of the exhibits, be the committee chairman. But the foreperson doesn't convince you to do what they want. They organize the discussion. There's no way to pick a foreperson. You can arm wrestle, throw fingers, draw names out of a hat. Don't go to the bathroom first, because you very well could come out the foreperson. I don't care. I've heard people say that. They pick them because they weren't there. It doesn't matter. I can't tell you how to pick one. Just get one. Throwing fingers is fine. It takes too long. You probably already know who's willing to do it, or maybe you've talked to each other enough, or you just say, sorry, you lose, you're it. But it's just organizing discussion. That's all it is. Just organize the discussion. Make sure nothing leaves. You'll have in your possession the verdict forms, the exhibits. You'll have copies of these instructions. Keep all that back there. When you come out, the only thing left to bring back out here should be all these verdict forms. Leave your notebooks back there. Everything else in the foreperson should make sure that goes on. How do you deliberate? Generally, the advice to you is to go back there and start talking about the case, replay the witnesses, but don't just say, I think something ought to happen. When you come out with your first opinion and then start discussing it, a lot of people realize their first opinion is not their best opinion. But once you threw it out there, then you got to figure out, how do I get my pride back and retool? So generally, don't go back there and just say, here's what we ought to do. What you think about this witness and how did this one come across? And do you understand the rules? And start into this discussion process, however you can do it. But eventually, then you're going to need to start getting to the point where you see a consensus is being built. If you immediately express an opinion, changing is sometimes hard, so work together to build a consensus. Consult with one another in the jury room, deliberate with a view of reaching an agreement. You can do so as a group, but without surrendering your own conviction. Each of you ultimately has to decide this case for themselves in this deliberation process. You might find somebody leaning on you to change your opinion. That's good, unless you feel pressured against your will to change your opinion. If they come at you with good arguments, maybe you should rethink your position because their arguments really are good. So like a certain amount of give and take and tension is usually the sign of a good deliberation. Just don't take it personally. Never surrender your own personal convictions just to get along. Don't be influenced by considerations of sympathy or prejudice. The law does not expect us to be robots and have no sympathy, no emotions, no prejudice, or no biases. That happens all the time. You have to set those aside. You're required to disregard them, to make your verdict carefully, to weigh the evidence, consider disputed questions of fact, apply the law to try to reach a verdict which the parties would be considering fair to both sides. Fairness is a big thing. Is this verdict fair to both the parties? Consider all the evidence regardless of who brought it forward. Do so with intelligence, impartiality, without bias, without sympathy, without prejudice. During the deliberations, if you have questions, you're welcome to write them down, which then comes to me, which goes to the lawyers to get you an answer. Like a magic doorbell. Knock on the door. Okay. The bailiff's like within earshot. He doesn't have his cup up against the door. So like pound on the door enough to get his attention. He'll come back, get the question, give it to me. I'll huddle with the lawyers, get you an answer. So when you get back there, there's a problem. You don't understand something, you want more information, you can get more information. Like we'll try to make sure you're not starving, like creature comforts will be provided. Like we're going to run into the lunch hour, so there's a way of taking care of it. I heard it yesterday, they'll do it today. So like we're going to want to cover all those bases. The clock is yours when the deliberations start. You watch me pay attention to the clock, right? I don't have a clock because you do. So how much time you need is up to you, not up to our expectations or our time commitment. We got to make sure that when you deliberate, you don't do so out of like human denial or fatigue. So yeah, we're going to watch to see how that goes. Like you might have me send you a question saying, is everybody fine? Are you awake? Do you need coffee? Do you need food? What do you need? One jury kept going, my personal record is 1:24 a.m. because that's what they wanted. They didn't want to go home. They were not coming back tomorrow because they were locked in and doing a good job. But it wasn't my clock, it was theirs. Until the verdict is announced in open court, you cannot indicate to anybody what it is. When you knock on the door saying we have a verdict, the bailiff will come, he'll tell me that you have a verdict. The foreperson brings the forms out here. And you hold on to them till everybody's here, and then we open the verdicts in front of all the parties. Don't say, oh, so-and-so, and this is the outcome, because the bailiff doesn't want to know that. And he shouldn't know that because it has to happen in this room. Up to this point, like I've told you, like not to talk to people, that still applies. Anybody outside the jury, that's off limits. If we deliberate today, you went home tonight, came back tomorrow, the rule's especially important. You can't tell anybody anything at all. Once the case is done, you can, in case I forget to say that. With regard to deliberations, I've got 10 of you and 2 extras. So the 2 on the end, 17 and 19, you're alternates. So you don't deliberate, but you're not done. You're what we call insurance. There's no guarantee in an hour somebody's not going to get a call that they have to go or that they hit the floor. or somebody had an accident, or the baby came early, or whatever it is. So you're not done. You're charged to not talk and to just wait. It's a luxury to have extras. I understand what I just did to you. I get it. But the number of times the jurors slot back in is not the majority, but it's enough that we're glad to have you for a reason. These folks get locked down and something happens along the way. We can't lose 3 days of trial work because somebody went through a stop sign or had a flat tire on a curvy road. Then all of a sudden you're back, we start all over, and the case gets done. So make sure the bailiff has your phone number. If you can be within like 15 minutes of the courthouse, I don't know what that means. If you live farther, just make sure Chris doesn't have to drive far to get you. He's not going to anyway, right? But he's big enough to, you don't want to cross him kind of guy. Anything you want me to deal with in the instructions, Mr. Klinger?
I had two minor issues.
Okay, we'll talk over there. Mr. Osborne, you got anything?
I do have something, yes, sir.
Okay, we're just gonna see what I didn't do right, or we're close. The vote is 6 out of 8, not 8 out of 8. It's the next paragraph down. So I've got 8 jurors. When you go back there, 6 and 2 is a vote in favor or opposed. So you always have to have 3/4. So if you take a vote and it's 6 this way and 2 that way, that's enough votes. It does not have to be unanimous to prove a case. In a civil case, it's 6 out of 8. That big deal? Yeah. I ever forget it? Yes. It's 6 out of 8. So you can have 2 people say, I don't agree, and if 6 people do, that's a verdict. And then the emphasis for the 2 alternates is not only not talking is important, but not talking to the media is important. So if you get hounded, it's anybody in the universe, because you're still in the panel. And then if the jury reached a verdict without you, you're going to get a call saying you're done. And now if you want to talk about it, you can. Anything else, Mr. Klinger?
Nothing from us, Judge. Thank
Mr.
you.
Osborne?
Your Honor, I would just renew any objections for the record, but nothing else other than that.
Fair enough. Overruled.
Thank
Or ruled, depending on what it is. There's a few typos. It'll be like 5-10 minutes before I get you some sets of instructions. When you look at the instructions, if you have a question about something, read the whole paragraph, not just the one sentence. Like you always think, I want to know more about something. The answer might be 3 words, but read the whole paragraph to do it. So you start your deliberations. We'll get the exhibits back to you, cleaned up sets of instructions. And thank you for your attention so far.
When's lunch?
Yeah, are you taking our lunch order?
Sure am. Shirley, we get their phone numbers.
Yes, I will.
And you can do that way right there.
Read this one.
Yeah, and then, if you would have to come back and deliberate, you'll have to notice that. We don't look at them or anything, even afterwards. You wouldn't be able to follow them anyway. Remember, dear.
Judge Hine. Sorry.
All right.